broken clock on the back wall, counting down till the last bell rings. You lock the door with the plastic smile, say this is just our little secret thing. Ink stains on my test paper, your hand leaning where it shouldn't be. You twist the rules like a gold ring, say it's love, say it's meant to be. Leave the kids alone, you're not a savior, you're a thief of home. Predator in school clothes, life in a cage is a place you go. See ya, Chomo, see ya, Chomo. We need justice, not a whisper, sorry, go. Leave the kids alone, leave the kids alone. You hide behind a chalk halo, fake men are on a crooked throne. They call you ma'am, they call you sir, you use that power, strip us to the bone. Female face, male face, same crime, same cold eyes when the door clicks shut. Courtroom shrug, they were almost grown. Light little sentence, deep little cut. Leave the kids alone, you're not a savior, you're a thief of home. Predator in school clothes, life in a cage is a place you go. See ya, Chomo, see ya, Chomo. Need justice, not a whisper, sorry, go. Judge with a tired handshake, gave her falls like it's half awake. You get years, we can count on hands. We get scars, we can't understand. Names on a list, they move you towns. Paper walls, you still prowl around. Kids in rows like loaded guns. You pull the trigger, then you run. Leave the kids alone, you're not a savior, you're a thief of home. Predator in school clothes, life in a cage is a place you go. See ya, Chomo, see ya, Chomo. We need justice, not a whisper, sorry, go. Leave the kids alone, leave the kids alone, leave the kids alone.
People, multiple communities, and charges prosecutors say involve some of the most disturbing crimes against children they've seen in years. Thanks for joining us tonight at 5:30. I'm Lindsay Stone.
And I'm Chris Jacobs. Today, 6 of those indicted for various child sex crimes were in front of a judge. WLWT News 5's Karen Johnson is live in Batavia for us with the details. Karen.
Yeah, hey, Chris, these details are very disturbing. Some of the allegations even too graphic to repeat. Of those indicted, 10 are men, 1 is a juvenile.
State of Ohio versus Richard Hogue.
6 defendants,
State of Ohio versus Benjamin Holden.
6 bond hearings,
State of Ohio versus Wayne Moore.
and a wide-ranging Claremont County crackdown targeting those accused of child sex crimes.
Your Honor, in doing this for as many years as I have, these are some of the most disgusting images I've ever seen.
Prosecutors say those images were found in the case against 18-year-old Benjamin Holden of Loveland. The high school student faces 20 counts of pandering sexually oriented material involving a minor. In another case, prosecutors say Daniel Bowling of Bethel was already on probation for a similar offense in Warren County when new images were found.
Obviously, he can't stop his issue. He can't stop looking at child pornography.
In one of the most serious cases filed this week, Samuel Ramirez, a Guatemalan man who investigators say is living in the United States illegally, is accused of raping 3 children. He faces 32 counts of rape. Ramirez is also being held on an ICE detainer. His bond was set at $500,000. Another $500,000 bond was given to Joshua East of Batavia, who faces 13 counts of pandering child sex abuse material.
Quite honestly, I'm terrified that he's got a 3-year-old daughter in the home because I've seen the images, and there are kids that age, some younger, some a little bit older.
Prosecutors say East claimed he was sharing images online to try and catch predators. A defense, they say, does not match the evidence. And for those who were arraigned today, not guilty pleas were entered on their behalf. Note, as for bond, each set of facts are different for each case, and bond ranges anywhere from $50,000 to, like you heard, $500,000. Reporting live tonight in Batavia, Karen Johnson, WLWT News 5.
Disturbing details there.
92-year-old man who admitted to sexually assaulting young girls at the church where he worked. He is going to prison.
And we're talking about this man, Charles Sullivan, pleaded guilty, and he was sentenced to 25 years in prison.
News 4's Mecca Thompson was in the courtroom in Pottawatomie County as Sullivan's victims told their stories.
92-year-old Charles Sullivan, accused of molesting young girls in a Shawnee church, back in court Monday, sentenced to prison.
I believe he deserves every bit of it.
That's a look at Sullivan walking up the Pottawatomie County Courthouse steps with family just before 1:30 in the afternoon. No cameras were allowed inside the courtroom, but he left in handcuffs. Carolyn Parks was there to witness his arrest as well. She's a former member of the Shawnee First Church of the Nazarene, where Sullivan served as a board member several years ago.
I attended from almost 18 years, from when I guess I was about 2 or 3 till I was 18. As a young person, you're kind of separated through Sunday school, and you don't see all of that.
4 victims reading impact statements in front of Sullivan and his family. One woman saying she was molested by Sullivan in the church gym, outlining the way he cornered her while touching and kissing her, holding her against her will.
I'm glad to see that the victims have justice.
District Judge John Canavan sentencing the 92-year-old to 25 years in prison, as Sullivan pleaded guilty to 2 counts of lewd or indecent acts to children under 16. Sullivan's attorney wanted probation, citing his ongoing health issues and concerns with conditions inside certain facilities under the Department of Corrections. Pottawatomie County District Attorney Adam Panter also attended the sentencing, telling News 4 in part he will now serve a sentence that will ensure he dies of old age in prison as payment for the horrible crimes he has committed.
That it was covered up for so long.
In Pottawatomie County, Mecca Thompson, Oklahoma's News 4.
All right. Thank you very much, Mecca. District Attorney Panter also expressed frustration as they weren't able to file charges on the church staff who failed to report the abuse. That inspired legislation passed last November extending the statute of limitations for failure to report abuse to match the statute of limitations for the abuse itself.
Sentencing today for Cody Tankey, charged with the sexual assault of a 13-year-old child, the La Crosse man to serve 20 years behind bars. Now, Tankey was originally scheduled to appear in court back in September of 2025 for his sentencing, but it was discovered he had fled to Puerto Rico in early October, where he was arrested later by federal agents and then returned to La Crosse. Arguments were presented today by both the defense and prosecution on what they believe Tankey's consequences should be. Tankey also addressed the court, apologizing only for fleeing and wasting everyone's time. Judge Levine decided that probation alone was not appropriate in this case, citing Tankey's criminal history and failure to take full responsibility for his actions. Tankey was then sentenced to a total of 30 years, with 20 years in confinement. The remainder of that sentence, 10 years of probation.
And now the decision to release Seha has sparked outrage from prosecutors and the victim's family.
ABC 10's Nazi Javid joins us now after talking with the survivor and uncovering disturbing new details from the parole hearing. Nazi, this must come as a horrific shock. How is she feeling about all this?
Truthfully, she was crying for most of our phone call, and at the center of this case is that survivor. She tells me she just found out about this today, and now she's being forced to relive everything all over again. Her case is really highlighting a controversial part of California law, which allows some inmates, including those convicted of sex crimes, to be considered for early release based on age and time served. The district attorney says this case is different. It points to years of horrific abuse and the lasting trauma left behind.
We have a man who was convicted of molesting his stepdaughter, raping her violently for nearly a decade in the 90s to the early 2000s.
A man sentenced to 139 years in prison, now recommended for release.
His name was Israel Seha, and the victim was a little girl when he started to rape her.
A childhood taken over years of abuse. We spoke with a survivor who just found out the parole board recommended her rapist for early release under the elderly parole law.
I never thought I'd have to see him again. You know, he may walk around with my kids. My children are out.
She says the abuse started when she was just a child, continuing for years inside her home.
It's not okay. I feel like I'm 15-year-old little kid again. It's not okay. And I just thought I was getting over everything and that I was going to be okay. I have to relive it all over again.
The DA says at least some of the incidents happened on this backcountry road at a home where the family lived back in 1999 here in Winters.
On one occasion, he tried to push her out of a truck to cause injury. On another occasion, he pointed a gun at her and he pulled the trigger and the gun either misfired or was empty.
The crimes were discovered in 1999 when she collapsed in public and was taken to the hospital. She was pregnant. DNA confirmed Israel Seha was the father.
This little girl was impregnated by this monster.
It started when I was 9, and I got pregnant by him when I was 15.
Prosecutors say the abuse escalated, including attempts to force a miscarriage.
He actually made me jump off the roof of the house. He took me to, I guess, like a witch doctor or something, and she tried to massage it out of me. He was just trying to get rid of it in really weird, sick kind of ways, you know what I mean? Metal coat hangers.
In 2000, he was sentenced to over a century in prison. Prosecutors say they believed he would never get out. But now the DA says the state parole board has recommended his release, saying he met the qualifications for elderly parole. The DA says one commissioner, Neil Schneider, called him an excellent citizen.
And the DA tells me that he made some disturbing comments in that hearing. They said that he admitted to having thoughts still of little girls, and when asked how he would handle those, he said that he would pray. The DA says that's just unacceptable. He's submitting a letter to Governor Newsom urging him to take action and have the decision recommending parole for this convicted child rapist reviewed and reversed. I did reach out to the governor's office and parole board. The governor's office did just get back to me. They say they have not received it for review yet, and they cannot comment on pending cases. Back to you.
My goodness, Nazi. And we should point out as well that according to state law, all reviews must be done within 120 days from the hearing or May 29th. His actual release date is unknown, but he's currently being held at San Quentin State Prison. Stay with us for updates.
Well, a man sentenced to spend 355 years in prison for sexually abusing young boys will stay put for at least another 4 to 6 months. The state parole board was considering the elder parole release of Gregory Vogelsang, but as Case Area 3's Melanie Wingo explains, his parole is on hold for now.
Gregory Vogelsang was convicted of sexually abusing at least 6 Sacramento County area boys between the ages of 5 and 11 from 1995 to 1997.
I'm the mother of one of Gregory Vogelsang's victims. It is a lifelong trauma that we have to deal with, and no other children or families should have to deal with this.
Since receiving his sentence for those crimes, he's been locked up. But in the fall of 2025, California's parole board granted Vogelsang parole. The state's current elder parole laws allow for Vogelsang, who's 57 years old, to be considered for release. But after agencies, including the Sacramento County District Attorney's Office, Sheriff's Office, and Governor Gavin Newsom requested a review of the case, it was referred to a larger Board of Parole hearings for additional review, which happened Wednesday, where a dozen parole commissioners heard public outcry over the decision to parole Vogelsang.
He's hardwired wrong. You guys have the burden and the responsibility to not allow someone like this in my grandbaby's community.
Do you have a son or daughter? Do you have a niece or a nephew? Do you have a grandson or a granddaughter? Have you thought about them encountering somebody like Mr. Vogelsang?
Concerned community members, survivors of sexual abuse, those with backgrounds in dealing with incarcerated people. The deputy district attorney who originally prosecuted the case against Vogelsang sounding off against his release.
I met with the boys and their families. I presented their testimony to the jury that ultimately convicted Vogelsang. I was in court when he was sentenced to 355 years to life.
Just one public commenter identified himself as someone in favor of Vogelsang's parole.
Elderly parole works. It protects public safety and it saves the state money. Despite very public opposition to elderly parole, there are many Californians who strongly support this common sense policy.
In the end, the Board of Parole Hearings deciding it will hold what's called a rescission hearing in 6 months to figure out whether the original decision to grant parole was improper.
I beg the parole board to please rescind his parole and don't put this predator on the streets.
In Sacramento, Melanie Wingo, KCRA 3 News.
Dixie County Sheriff's deputies say charges are moving forward as part of an investigation into sexual crimes against children. 32-year-old Hal O'Day faces charges including capital sexual battery and lewd and lascivious molestation. Deputies say they won't release specifics to protect the victims. Court records show O'Day was found guilty of 5 counts of animal cruelty. That was in 2020. He was still under court-ordered supervision when he was arrested in this new.
All new at 6, a former high school flag football coach behind bars tonight. Tyrese Jones is facing a slew of charges, including offenses against students by authority figures, child abuse, and battery. Jones used to coach at Miami Northwestern Senior High School, but has since been reassigned. Miami-Dade County Public Schools sent us a statement saying in part, quote, the type of behavior this individual is accused of will not be tolerated. The statement goes on to say that the district has initiated employment termination proceedings.
A former Oregon school principal is headed to prison for possessing child pornography. 55-year-old Jeremy Williams of Longview was sentenced to just over 5 years behind bars after pleading guilty to 3 charges. Investigators say they got a tip on social media, which led to the search of his electronic devices, where they say they found he was sharing sexually explicit pictures of minors through online platforms. At the time of his arrest in September, Williams was already on paid leave because of comments he made about late conservative activist Charlie Kirk. He'd been the principal at Rainier Junior Senior High School since 2022, so he was only on the job for about 3 years. Authorities say they do not believe any of the images involve students at his school. He will now have to register as a sex offender and will be supervised for 3 years after his release.
A Fort Wayne man is sentenced after pleading guilty in a child pornography case. 62-year-old Richard Conger pleaded guilty to possession of child pornography and 1 count of inappropriate communication with a child. He was sentenced to 6 years in prison with 3 years suspended. Conger also had 302 days of jail credit and will be on probation after his release.
The grandson of tennis legend Bobby Riggs has been sentenced to 20 years in federal prison. Daniel Riggs pleaded guilty to child sex crimes. The 33-year-old was a tennis coach in Fort Lauderdale. Detectives say he used his position to sexually abuse 2 minors who he coached. The victims were 15 and 16 at the time. Once he is released from prison, Riggs will be required to register as a sex offender.
A Houston doctor is now off the job after disturbing allegations involving a child overseas.
Investigators say he is now facing both state and federal charges. KPRC 2 News reporter Ricky Munoz is live now from downtown Houston. And Ricky, what do you know so far this morning?
Hey there. Now that doctor is being held here at the Federal Detention Center, and investigators say that this Houston anesthesiologist has been communicating with a young girl from overseas for years, and they say that those messages turned into threats and exploitation. Now on your screen, you're going to see 42-year-old Dr. An Vaughn. Now investigators say that this all started after a message from a girl in the Philippines raised serious concern. She wrote, "I'm going to kill myself when I get home." That's when the National Center for Missing and Exploited Children alerted Houston police. Authorities say the girl, now 15, had been talking to this man for years in apps like Discord. Now she told investigators that he threatened to release explicit images she sent when she was 10. Now take a look here. When police searched his home in February, they say they found more than 50 images of child pornography inside a hard drive inside a toilet tank. Now, records show he was first arrested and later released on an $80,000 bond with no restrictions on practicing medicine. Now, the Texas Medical Board says that they pose a continuing threat to the public and has now suspended his license. Investigators say he was arrested again in March, this time on federal charges. Now, right now, the FBI has not released any details on this case. As soon as we have more information, we'll make sure that we update everybody on air and online on click2houston.com. But for now, reporting live in downtown Houston, I'm Ricky Munoz, KPRC2 News.
All right, Ricky, thank you.
Welcome back to CBS Mornings. Joseph Duggar, one of the stars of the reality TV show 19 Kids and Counting, is under arrest this morning. He's accused of sexually abusing a 9-year-old girl 6 years ago in Florida. The girl told police that Duggar allegedly touched her inappropriately on several occasions. Tom Hansen has more.
This is the story of my family. We're the Duggars.
Joseph Duggar was just 13 years old when cameras followed him and his very large and conservative Christian family on the hit TLC show 19 Kids and Counting. Now, 18 years later, he's the second sibling to be held behind bars, facing child sex abuse charges after investigators in Florida were contacted about a report of a past sexual abuse incident. According to the Bay County Sheriff's Office in Florida, the now 31-year-old was arrested Wednesday for several incidents dating back to 2020, when police say his family was on vacation in Panama City Beach. Detectives say Duggar allegedly molested a then 9-year-old girl. She alleges he repeatedly asked her to sit on his lap, and at one point, she says he touched her inappropriately underneath a blanket. Duggar was taken into custody on Wednesday in his home state of Arkansas, where authorities allege he admitted to the actions to the victim's father and investigators and is awaiting extradition to Florida. His arrest comes nearly 5 years after his brother Josh was accused of molesting 5 girls, including 4 of his own sisters. In 2015, with 19 Kids and Counting now canceled, Joseph spoke to cameras on their spin-off show Counting On about his brother.
So the day before everything broke loose on the police report and all that from Josh's past, I was actually about to head out on a missions trip. It blew my mind. I had no idea. I don't think there's any way any of us would have known that my brother's living such a secret life.
Josh was found guilty of possessing child pornography in 2021. The Duggar family has not responded to a request for comment from CBS News. For CBS Mornings, I'm Tom Hansen.
One man has pleaded guilty to 3 counts of sexual assault of a child, but he has not yet learned his sentence. Alberto Zambrano entered the guilty pleas before Judge Stevens. According to court documents, the victim was younger than 16 years old at the time. Now, if he had gone to trial and been convicted, Zambrano could have faced 2 to 20 years in prison. Now, under the plea agreement, his sentence will not exceed 15 years, and probation remains an option. Judge Stevens ordered a pre-sentencing report before making a final decision.
First alert this morning, Menasha police arrest a man suspected of possessing child sex abuse materials. The department says it got an online tip back in January about a man on the 1200 block of Whitman Park Lane. Officers went into an apartment complex there last Thursday and arrested 26-year-old Taylor Lawrence. He appeared in Winnebago County Court for the first time on Wednesday. Lawrence is facing several charges, 5 for possessing child pornography and 5 for child sexual exploitation. Online court records show he's set to appear in court twice next week. The state's
40-year-old man is behind bars tonight, charged with attempting to meet a 12-year-old in Knoxville with some bad intentions. Knoxville police detectives, along with agents from the Department of Homeland Security, arrested Ryan Garrett on a federal complaint. Officers say they arrested Garrett after he arrived to meet the child. He made his initial appearance in federal court today, charged with coercion or enticement of a minor for the purpose of an illegal sexual act.
All right, it's update time. This next article is his sentence.
New tonight, a Maryville man is heading to prison after admitting he tried to lure children here in Knoxville. Federal prosecutors say 41-year-old Ryan Patrick Garrett will serve 10 years behind bars, followed by 30 years of supervised release, and he'll have to register as a sex offender. Investigators say he made plans to meet who he believed were a 9 and 12-year-old, but instead was arrested by Knoxville police and U.S. Department of Homeland Security investigators. Officials say the case is part of a nationwide effort to crack down on child exploitation.
Now we begin with our first story tonight that may not be suitable for younger viewers. An alarming child pornography arrest in Evendale involves a local school and hundreds of thousands of child porn images and videos.
Police arrested the suspect on Friday and just released information about the disturbing allegations.
The suspect is 24-year-old Rain Phoenix Brown. He lives with his mother in this upper-middle-class Evendale neighborhood. We knocked on the door today, but there was no answer. Police also knocked on the door in February after a 4-month investigation prompted by a tip in October. Police report a concerned citizen said Phoenix Brown had video of a 14-year-old girl having sex with a dog. An investigation ensued, uncovering statements made through the Discord and Telegram apps telling another user, "You gotta find a 5th or 6th grader because I'm a pedophile ×3 and I want to rape them." The other user tells the suspect, "I have dog porn." Phoenix Brown replies, "Send." Inside the suspect's home, Evendale police confiscated his electronic devices, finding hundreds of online chat discussions, 15,000 videos, and several 100,000 electronic images, some of which were created using AI. An affidavit states Phoenix Brown admitted also having video of a 4-year-old child having sex with an adult. When doing a story last month on AI generative porn, I spoke to the National Center for Missing and Exploited Children, who said this form of child exploitation is exploding.
When we took a look at the first half of 2025, so between January 1st and June 30th of this year, we had already received over 440,000 reports.
Perhaps equally as disturbing, documents filed with the court mentioned photos of children from a local parochial school. Police do not name that school and say none of the children were victims in any crimes related to the suspect. Federal public defender Steve Nolder told me last month for many of his clients, child porn is feeding a progressive, insatiable desire for obscene materials.
They start looking at images of maybe snuff films. That doesn't get it anymore. Then they look at animal abuse films. That doesn't get it anymore. Then they start looking at child pornography. And it just is an addiction of some sort.
Phoenix Brown is charged with various felony child pornography violations punishable by up to 24 years in prison. He's currently in the Hamilton County Justice Center on a $300,000 bond.
New tonight, 2 Raleigh parents are facing child abuse charges. Tamara and Christopher Ross are accused of pouring scalding hot water on their child. The 11-year-old suffered severe burns. The parents are also accused of holding the child against their will. Christopher Ross faces an additional misdemeanor child abuse charge, and they both have had similar charges in the past. They're expected in court tomorrow.
Riverside County school psychologist is facing charges accused of exchanging sexual photos with someone he thought was a child.
Assignment editor Mike Rogers at the desk. Mike, that person he thought was a child was actually an undercover cop.
An undercover cop, and tonight that person is facing charges related to this, and because of his work as a school psychologist, there is a concern that there are more victims out there. I want to show you his photo. That's the reason we're showing you his photo here, is because police believe there are more victims. Now, this person was arrested by the Riverside Police Department. They say his name is Paul Ryan Coleman of Yucaipa. Now, they say he reached out and tried to exchange hundreds of sexually explicit messages, photos, videos, other things like that with an undercover investigator who was posing as a 13-year-old child. After the 3-month investigation, he was arrested at his home in Riverside after he tried to meet with the person whom he believed to be a child. He was instead arrested by the child exploitation team. Now, they do say that he worked as a school psychologist, a licensed school psychologist at New View Union School District and New View Bridge Early College High School in the city of Nuevo. That's in Riverside County. So that is why they are concerned that there could be more victims out there. They want you to look at his photo, know his name, and if you believe that you or your child or anybody you know may have been victimized by this person, the Riverside Police Department detectives would like to hear from you. Meanwhile, he's being held on 3 felony counts related to the charges against him. Guys?
All right, Mike.
He's been arrested on child porn charges. Michael Manning was arrested by Winterville police yesterday. According to warrants, Manning had several videos of boys between 5 and 12 years old engaging in sexual activity. The warrant lists February 1st as the date of the offense. He was charged with 10 counts of third-degree sexual exploitation of a minor. Manning was taken to the Pitt County Jail, where he is being held without bond. Now, he is scheduled to appear in court today. And we have another child porn arrest to bring to your attention. This one in Martin County, but a man arrested is from Chicago. Martin County deputies arrested Daniel DeMudler yesterday. The 33-year-old man is accused of having multiple videos showing a 10-year-old girl engaging in sexual activity, according to warrants. Now, he is charged with 6 counts of second-degree sexual exploitation of a minor. A court release order says DeMulder has no ties to Martin County and was extradited from Michigan. Now, he was booked into the Bertie Martin Regional Jail under a $750,000 bond. Court records show he will be appearing before a judge later today.
Greenville man is behind bars as police in White Pine investigate a child sexual abuse case. Officers with the White Pine Police Department say they arrested 58-year-old Thomas Payne today. He's facing a count of rape of a child and 5 counts of aggravated sexual battery. Police say the investigation began earlier this month, tied to allegations of abuse dating back to 2022. Authorities say the case is still ongoing with more charges possible as they work with another jurisdiction.
40-year-old Adikir Khan was indicted today as well for felony child pornography. He was arrested 2 weeks ago during an internet crimes against children operation. It was led by the Department of Homeland Security and DPS, also Beaumont and Nederland Police, and involved downloaded material.
Covering news that matters. Fox 23 News at 5 starts right now.
2 child rape victims who've waited decades for justice say they're worried the charges against their abuser could be dropped. Thanks for joining us. I'm Rick Marinon in for Shay tonight.
And I'm Nathan Thompson. Sammy Freidenberg is facing multiple molestation charges in Osage County and Tulsa County. But after he was sentenced to 25 years in Osage County, he filed to withdraw his guilty plea.
Fox 23's Devin Lyon joins us live in studio. Devin, you have an update from the court, and you also spoke with the victims today.
Yeah, and to put everything in perspective, the victims said they waited about 25 years for justice, and Freidenberg was just sentenced to 25 years. So they've waited for as long as he will be in prison. But now Freidenberg wants to get rid of his original guilty plea, leaving the future uncertain for this case in both counties. We brought you coverage of Sammy, Dan Freidenberg, Alexis, and Sarah Payne. Both say he abused them for more than a decade as children. Freidenberg was in their foster family, the son of their foster parents, but also a foster parent himself. The 2 women say they're 2 of several victims to come forward. Freidenberg was arrested in 2023. He has 9 charges in Osage County and 4 in Tulsa. Since the abuse was in 2 different houses, he took a plea deal in Osage County when a judge sentenced him to 25 years. But this week, Freidenberg applied to remove his guilty plea. The Osage County judge can accept the plea withdrawal and send the case to trial or reject it and let the sentencing stand. Now, the 2 women are concerned about ever receiving justice in either county. They say they deserve justice for what happened to them, and this drawn-out case is why it's so hard for victims to come forward.
Look at the evidence against him. This man is a monster, and he's lived his life terrorizing children. They need to take a big look into the case itself and just see that this man has harmed a lot of people, and it's not something that's going to end unless they make it a point to end it.
I literally lived my entire childhood being terrorized, being abused, being threatened. And I'm supposed to just be like, oh, okay, 25 years, great. No. Osage County has stuff that happened. Tulsa County has stuff that happened. Tulsa needs to hold him accountable just as much as Osage is.
And I did just receive a statement from the Tulsa County District Attorney's Office literally just a few minutes ago about the crime that was charged in Tulsa County is the same in Osage County. I'm paraphrasing their statement a bit here, but Tulsa County has kept its case open to ensure justice was served for the victims. They say the plea agreement reached in Osage County is the equivalent of a life sentence to this defendant, and so justice has been served. Essentially, then, they're waiting to see what happens with this plea withdrawal filing before they make any move. Now, obviously, there are several questions in this story I'm still working to get answers to. How often are plea withdrawals accepted? Why the Tulsa County charges could be dropped? And how abused children fall through the cracks in the state so often. I'll be getting some of those answers for you throughout this week and updating you on air and on Fox23.com.
In jail after a 3-day staying this in Shelbyville in Shelby County. There are their pictures. The targets accused, sex offenders looking to exploit children online. The investigation involved more than 75 officers from local, state, and federal agencies.
And while the Internet Crimes Against Children Task Force says it's one of the most successful in Indiana, Fox 59's Scarlett O'Hara explains why the prosecutor says their work is never finished.
Police say nearly a dozen men each tried to meet up with a teen girl they believed lives in the house behind me. Only she was always a cop, busting a record-setting number of predators. I wish I could come pick you up. There might be a small legal problem with kidnapping a 15-year-old girl, even if we both know you're grown. Court documents say the man behind that keyboard was a lawyer, James Klemek, who even once served as chief counsel to the Indiana Securities Commissioner.
There's no profession that is beyond the reach of this type of activity, unfortunately.
Nor is there a shortage of predators lurking on popular sites like Reddit and Craigslist, and lesser-known apps like Hush or Tagged.
I wish it was harder to find these people. It shouldn't be as prevalent as it seems to be.
Prosecutor Brad Landwerlin explained how, although this was the first large-scale investigation of its kind in Shelby County, it yielded 11 arrests over just 3 tireless days, a record for the Internet Crimes Against Children Task Force. 2 suspects drove from out of state hoping to meet with a minor for sex. One brought his brother, and another, named John Altman, admitted to creating child sex abuse images of a 1-year-old, according to court documents.
We are hoping to address the legislature next year. It's a budget year with some additional funding for, frankly, child pornography and Internet crimes against children investigations.
Landwerlin says the problem with ICAC is a major lack of funding. Many of the officers, especially federal, working without pay, yet still unable to keep up with the seemingly endless supply of sex criminals.
It takes a lot of time, a lot of effort. And unfortunately, we simply don't have the ability to go after all of it. We don't have the ability to go after half of it.
That's why he encourages parents to always remain vigilant.
Just think, just in Shelby County, over those 3 days, how many people had real conversations and had real meetings that took place in your home when your 13-year-old invited this guy there.
In Shelbyville, Scarlett O'Hara, Fox 59 News.
Scarlett, thank
you. Houston anesthesiologist accused of sexually exploiting a child is now temporarily suspended from practicing medicine. 42-year-old Dr. An Q Vaughn, pictured here on your screen, is in jail tonight facing both state and federal charges. Corley Peel is in the newsroom with the disturbing allegations against him.
Keith and Stephania, Ann Van is in federal custody tonight after records show he threatened to blackmail a young girl overseas while stockpiling child pornography in his home. The investigation into this anesthesiologist, Ann Van, began in March 2025 with a troubling message from a girl in the Philippines saying, "I'm going to kill myself when I get home." The National Center for Missing and Exploited Children alerted Houston police. Investigators quickly identified 42-year-old Van as their suspect. The doctor, who has hospital privileges at Townsend Memorial Hospital, HCA Southeast Hospital, Baylor St. Luke Medical Center, and HCA Medical Center. Authorities say the girl, now 15 years old, reported she had been communicating with Van for years using chat apps like Discord. The girl told investigators Van threatened to release explicit images she sent him when she was 10 years old. In February, Houston police searched Van's home, finding more than 50 images of child pornography hidden on an external hard drive inside a toilet tank.
On Van,
records show he was arrested and later released on an $80,000 bond without any restrictions on his ability to continue practicing medicine. The Texas Medical Board says that posed a continuing threat to public welfare, prompting an emergency suspension of his license without prior notice. Records also show the doctor was arrested again in March, this time on federal charges. The FBI has not released details about Van's case at this time, but we will keep you updated. In the newsroom, Corley Peel, KPRC 2 News.
A Tipton County man is in jail on a $50,000 bond facing child sex abuse charges. 27-year-old Zachary Ty Clark was arrested on Friday, formally charged with statutory rape by an authority figure and sexual battery by an authority figure. The Tipton County Sheriff's Office says the victim told staff at the school about the assault. Clark's next court date is next Tuesday.
The maximum sentence was handed down Friday afternoon to a 69-year-old Torrington man convicted on a horrific crime with devastating impact. Alvin Sirovatka was found guilty by a Goshen County jury in October on charges of sexual exploitation of a child and sexual abuse of a minor in the second degree. Court records show that Sirovatka admitted to touching a 4-year-old girl's privates while pleasuring himself. During Friday's sentencing, Judge Edward Buchanan stressed how heinous these crimes were and sentenced him to 10 years, 9 months to 12 years on the first count and 18 to 20 years on the second count, which will be served consecutive to each other. He also ordered a $10,000 fine on each count and noted that restitution to the victim may be considered at a later point in time. Co-defendant Angela Montoya has pleaded not guilty to associated charges for allowing Sirovatka to have access to the 4-year-old.
A Latson man is facing child sexual abuse material charges. 16-year-old Glenn Kiblee was arrested Wednesday and is charged with 6 counts of sexual exploitation of a minor in the 3rd degree. Each charge carries up to 10 years in prison. The Internet Crimes Against Children Task Force and Charleston County Sheriff's Office made the arrest following a tip from the National Center for Missing and Exploited Children.
Madam Reporter, can you hear me?
Yes, sir, Judge, I just can't see you.
Okay, I'm trying to turn on the camera now. There we go.
Perfect.
All right, the court will call up, well, first of all, we'll go on the record this 18th day of July 2025, Judge Broward presiding. Court calls up State of Idaho versus Jason Ernest Stark, CR 03-24-04391. Mr. Stark is being represented by Kyle May, and the state is being represented by Dan Taylor. Good morning, gentlemen.
Good morning.
We are scheduled for a sentencing today in this case. There was a pre-sentence investigation report that was filed with this court on the 16th day of July 2025. Mr. Stark, have you received a copy of that report?
Yes, Your Honor.
And have you had an opportunity to review that report with your counsel?
Yes, Your Honor.
Mr. May, was there any factual corrections or errors contained in that report that you wish the court to take note of?
Yeah, specifically there's some minor ones, but one of the biggest ones, and that was on page, and it was mostly on the PSE.
Okay.
That was submitted to the court. It's on page 8, I believe.
Right over there.
That last paragraph on page 8, where it starts in May of 2024, Mr. Stark's cell phone was reviewed and contact information and nude images of 2 of the 6 accused victims were found. So that is incorrect. There was, at least from our standpoint, we had never received anything. The state had no images, nothing like that. They had search warrants, they had things like that were issued on that. In discovery, we never received anything like that in discovery. There were never any images or anything like that found on his phone from what we had received in discovery. So that is an incorrect statement on page 8.
Just a second. Mr. Taylor, any objection to that correction?
No, Your Honor.
All right, Mr. May.
And then just on page 7 on the PSI, there was a couple of things. He said never received a degree or certificate. You received a degree in AAS, which is Associates in Applied Science, and a certificate in auto body. You wanted the court to know that. Employed as a supervisor at Lifetime in, it says Idaho, it's supposed to be Utah. And in there it says that he does not belong to any social or community organizations. He is a member of the LDS Church. And And those were basically the corrections that we wanted the court to take note of.
Okay. I will take note of those corrections, and I will enter an order that will attach to the PSI making note of those corrections as well. Mr. May, are you prepared to proceed with sentencing?
Yes, Your Honor. I guess I know this court has been presented a binding Rule 11 agreement. I know the court was going to wait to pass judgment on that pending looking at the PSI, the pre-sentence investigation report, and the psychosexual evaluation report, and then the court was going to make a judgment as to if this court was going to follow the binding Rule 11 agreement. So I just asked the court what its position is on that.
So the court already found itself with the, as you stated, the option to choose to not go along with that after the PSE and the PSI. I'm not going to exercise that right now. Well, I'm not going to exercise that. So we will continue with the binding plea agreement as stated. And the sentencing recommendations contained therein.
Okay, thank you, Your Honor.
Yes.
So, Your Honor, I guess with the court following the binding Rule 11 agreement, pursuant to that, obviously, I guess would just follow with that is that the defendant here is going to be incarcerated as part of the agreement. He's going to go and do a 10-year fixed sentence with a 20 years indeterminate. And one of the things that we wanted to point out to the court is he was arrested on April 25th of 2024. That was when the warrants were executed in Utah. He didn't get here till like May 6th, I think, on the criminal complaint. But that would be 449 days of credit served up to this point. I think at this point with the court following the binding Rule 11, the court has discretion with the amount of fines. I would just take into consideration because this is a 30-year sentence, and obviously 10 years of that he's going to be at least incarcerated, potentially more. I would ask the court to consider the amount of fines and I guess not additionally punish the defendant here in this case because he's going to be incarcerated for a quite lengthy period of time to be able to even pay those. And so I would ask the court to institute a lower fine in this case. I think obviously the sentence is reasonable, Your Honor, and that the court follow it obviously through the pre-sentence investigation report and the PSC. Obviously he came back moderate on the PSC and he came back actually low on the PSI with regard to the recidivism rate. With that too, obviously the court taking into consideration the last time when Mr. Stark was on parole, he actually did well before anything happened again. And because there's going to be that long 20-year tail, I think the court can rest assured that he will be supervised, and if he's ever released, that there'll be someone there supervising him for probably the majority of his life. Thank you.
Mr. Stark, is there anything that you would like to say to the court in allocution?
No, Your Honor.
All right. Mr. Taylor, turn to you.
Your Honor, there are two victims here today. Before I go that far, all named victims in this case have been notified pursuant to the statute. Two of them have exercised their right to be present today. I believe one of them would like to make a statement to the court. And their mother is here as well. And that puts us in something of an unusual spot in this case because the parents of juveniles, as the court's aware, be qualified under the statute, but they're no longer juveniles. But they were juveniles at the time the offenses were committed. So their mother is present, and she has requested that I ask the court if she'd be allowed to make a statement in regards to what was going on when they were juveniles and when these events were taking place. I said I didn't know the answer to that, and I would leave it to the discretion of the court.
All right. Mr. May, any comments on that?
I mean, I guess, Your Honor, is where we're at is that obviously we would be in the position of, look, they're adults now, and that's
they have the right to do their victim impact statement, and that's where we would be at. I mean, I guess if the state wanted to call, I mean, should they have the right to call witnesses? And as if she wanted to call her to give that victim impact statement, he'd have that right. And I would just say, but with just coming up and doing a victim impact statement, we would just ask that the victims themselves do it, Your Honor.
Thank you. I am going to allow the mother to speak in regards to a victim impact statement. She, having been present during the time of the child's life under which this was occurring, I do think would have insight in regard to how that impacted the victim, particularly since children's perceptions can certainly change or be altered throughout adolescence. And so in regard to the impact on the victim, I do think that's appropriate, so I will allow that.
Very well, Your Honor, in this case, but the state believes it's important to make a record of a few things. So in regards to the psychosexual evaluation, I think one of the most important things is actually the second sentence of the first page under preliminary statement. Risk classification is the examinee's assessed risk to reoffend when compared to other sex offenders, not the general population. He's been tagged as average or moderate. Dr. Hatzenbuehler uses both interchangeably. They mean basically the same thing, but that is in regards to other people like him, not to everybody else. And we know that he's already reoffended. This is the second time, as the court is aware. So the sentence that we have agreed upon is fair, and it certainly, I think, reflects what needs to happen in this case. This was a premeditated and substantial period of grooming that occurred. In a lot of ways, grooming, at least from the state's position, is at least as harmful and potentially more harmful than just a physical assault that results in this sort of conduct. Because what he's doing is he's eroding their self-defense mechanisms. And at such a young age, he's almost preventing them from being fully formed in the first place. By gaining their trust and then using them to fulfill his own needs, the victims will not have the same mental processes as people who weren't subjected to this sort of behavior. And I think it's important to note that he did so under the guise of being their friend. He went to the mall as a man in his early to mid 30s and played Magic the Gathering with kids that were in middle school. And he didn't do it because he wanted to spend time with them. He didn't do it because he wanted to make sure there was an adult there to be looking out for them. He did it so that he could take advantage of them. That's the same. That's almost the same thing as the proverbial van that says free candy on the side. That's the man that we're dealing with. One of the things that I found most troubling when going through the materials, the psychosexual evaluation, the PSI, is when he sits down with Dr. Hatzenbuehler, the very first time he says, well, I didn't really do anything. There were lewd comments I shouldn't have made. And then as the process goes on, there's a little, he says, well, okay, I touched him and I shouldn't have. Well, I just did it with the one kid. Throughout the psychosexual evaluation and the pre-sentence investigation, he is downplaying his actions and victim blame. He continued to maintain that his only contact offense involved the touching of one of his accusers on one occasion, and that the one sexual harmful contact with one of the 6 boys occurred 1.5 years after interaction with a group of boys. And then he takes it a step further and says, well, when one of the victims moved in with me and I had to kick him out because I was getting married, then they all came after me, and that's why there's 6 accusers. Fine, all right, so that might account for 2 because they're brothers. But why would these other kids say that these things happened if they didn't? They have no motivation to do so. This is him deflecting, this is him downplaying, this is him not taking responsibility. He pled guilty to the one count, but I don't think he has fully internalized, probably because he doesn't have the tools to do so, exactly what it was he did and how harmful it was. He really, I mean, I would like to say that that's fixable, but he's already, I don't know anything about the laws from the state where this happened before, but I think it's safe to assume they have some similar mechanisms to what we have here, and they didn't work the first time. So that brings me to the two bill factors in Idaho Code 1925-21. As the court is aware, community supervision is supposed to be the go-to. None of the things under 1925-21 sub 1 apply. The defendant's criminal conduct neither caused nor threatened harm. We know it did. We just heard from one of the victims. The defendant did not contemplate that his criminal conduct would cause or threaten harm. He spent years grooming these kids. He knew it was going to cause harm. He just didn't care. The defendant's criminogenic needs indicate the defendant will benefit from supervision and treatment in the community. It didn't work the first time. We know it did, because he reoffended. The victim of the defendant's criminal conduct induced or facilitated the commission of crime. They were minors. That's not applicable. And in regards to sub F, that's not even possible. But what is important, Section 3, the following factors, while not controlling at the discretion of the court, shall be weighed in favor of imprisonment. And he checks all of them. Undue risk that during the period of suspended probation, the defendant will commit another crime. He's already done that. We've already been there. A lesser sentence would depreciate the seriousness of the crime. Absolutely. Anything less than prison says that this is okay. Imprisonment will provide appropriate punishment and deterrence to the defendant. Well, I hope so. I hope this doesn't happen again. And finally, an appropriate deterrent for other persons in the community. Yes, absolutely. The court has already said, yes, we're going to send this message. And then the very last thing, multiple offender. Yes, he is. So I don't want to take up a lot of the court's time by going through with a fine-tooth comb everything. But there's certainly enough here that makes this justifiable. And that's why we came to the agreement that we did. And again, the state thinks it's fair and appropriate. So, thank you.
All right, Mr. May, is there anything else from you?
I guess I'm just a little bit confused, Your Honor. I don't, from our standpoint, we're arguing that the binding rule 11 is fair. I think the court thinks it's fair, the state thinks it's fair. The rule 11 basically says he's going to be incarcerated. I think at this point we've come to that agreement, and that the agreement supports an appropriate sentence in this matter pursuant to all the factors. I could get into the details of some of the things that were beneficial for him, but at this point I think that's moot at this point due to the fact that there's an agreement. The court is accepting that agreement, and so is the state. And so that's where we're at, and I think it's appropriate, and I think that my client, we spoke with him, and he has made this agreement, and he's okay with it. And that's where we're at this point in time. He does, I think in there's specific things that he says that he is going to plan on doing to try to improve himself while he's incarcerated, and do the treatment programming that has been recommended throughout the PSE and the PSI, and he plans on doing that while he's incarcerated to be able to overcome some of the things that and challenges that he faced with addictions and things like that he has, and he understands that he has those. And I think he understands that it would be appropriate at this point in time to be able to do that and while he's incarcerated for the period of time that he's going to be. Thank you.
Thank you. Mr. May, is there any legal reason that you're aware of that the court should not proceed with sentencing?
No, Your Honor.
Mr. Stater?
No.
Okay. The court does consider the 4 factors of criminal sentencing in this matter: punishment, deterrence, protection of society, and rehabilitation. Protection of society being the most important factor that this court must consider, with the other 3 having great weight. I also consider the pre-sentence investigation report, the psychosexual evaluation, the attached documents to the pre-sentence investigation report, the comments of the victims and one of the victim's mother, the reports and information attached to the complaint, and other information that has been appropriately provided to this court. I also consider the recommendations and statements by counsel, as well as the binding plea agreement. I do want to address one thing, I suppose, before I begin. Mr. May, you said that parties think that this plea agreement is fair, and then I wrote it down, the court thinks it's fair. I actually do not. I have accepted this plea agreement, and there are reasons the court accepted this plea agreement. I recognize, having done this for a long time, that there are often different considerations that the parties take into account that the court doesn't have information about. There are issues of evidence, there are issues of the impact on individuals if they are to go to trial. There are a lot of different things. From the defendant's side, they have different considerations in relation to the likelihood of a conviction, for example, versus being able to receive a lower sentence. These are all different matters that are not taken into consideration by this court. But I do take them, I do take binding plea agreements with a certain amount of weight, because I'm not in that room. I'm not in that room at mediation. I'm not in that room when these things are being decided. I don't have access to all of the documents. What I did ask at change of plea was whether the victims had been notified and took part in the mediation, and the plea agreement as required under the Constitution and by statute, and it was affirmed that they had. And that was important to me as well. But to be quite frank, Mr. Stark, based on your conduct, you likely deserve more than 10 years sentence. I've agreed to that. And I'm going to follow that agreement. But your conduct was egregious. Just as stated in this courtroom today by that mother, by that victim, you have ruined lives. Your conduct was selfish. Your conduct disregarded what would happen to other people. For your own sexual proclivity, you groomed these children. And they will bear those scars for the rest of their lives. And you did so, even having done so before. Even having been through treatment, having understood what this could do to somebody, you, over the matter of a great deal of time, this wasn't even just a single instance, groomed these children. The court does consider what you pled guilty to. I also consider the circumstances that are surrounding these instances. I look at the polygraph examination that you completed. In which the first question victim 1 telling the truth when he says you had hands-on sexual contact with him up to 100 times. Your answer being no, and a significant reaction. In layman's terms, that means that you failed that question. It was inconclusive that you had hands-on sexual contact with other juveniles, but later on, when you were asked whether you're, other than the ones we've discussed of your accusers, have you had hands-on sexual contact with any others? Significant reaction. Other than your accusers, have you ever received, to your advice, naked pictures of any of those boys? Significant reaction. Now, I know that polygraphs aren't infallible, but I also recognize that we use those as an indication of risk. I find you to be a great risk to this community. I find that you harmed those children. I find that you did so without consideration of what it would do to them. I find that you are deserving of punishment, and that this court must enter a sentence that will protect society. That's a great reason why I accepted this plea agreement. It's the reason I did not back off of it after reading this information, because this plea agreement at least guarantees that you will be incarcerated for the next 10 years, as you deserve, and potentially for another 20 after that. I don't find either, oh, I guess I do find, I don't think you've taken accountability. Not entirely for the conduct that you committed. I agree with Mr. Taylor. I have a hard time believing that 6 young men would come out and put themselves through this. Potentially put themselves through a trial. The shame and the hardship that these things incur, simply because they wanted to get back at you because one of them was kicked out of a house. That simply does not compute. Another one because the other one you stated because he had disclosed things to a treatment counselor, that must be the reason. That does not make sense. I don't believe it makes sense. I've reviewed this information. I find their statements to be credible. And here, you have admitted to committing a lewd act on one of these children, to soliciting other acts at a minimum. And you even said here in your polygraph that had you been provided the opportunity, you would have taken it. You are a risk to this community. And quite frankly, how dare you commit this kind of conduct on children, young teens. I do impose on you, in count 1, a 10-year fixed 20-year indeterminate sentence for a total unified sentence of 30 years. I'm going to impose that sentence. I will grant you 449 days time served as set forth by statute and required by statute and the plea agreement. I'm going to run that concurrent with count 2. I'm going to impose a fine in this case that is indicative of your conduct. I have considered this amount, whether you'll be able to pay back this amount. I consider your age and your employability after incarceration, and I find that this fine is appropriate given the circumstances and those 4 factors. So I will impose a fine of $10,000. I'm going to impose court costs as set forth by statute. I'm also going to impose a $5,000 fine pursuant to Idaho Code 19-5307, which shall act as a civil judgment against yourself and entered on behalf of PN. The court issues this, or will issue this as a separate order, imposing this fine on behalf of the victim. This fine is ordered solely as a punitive measure against the defendant and is not based on any requirement of showing of need by the victim, and it is unauthorized under subsection 2 of that section. In count 2, I will impose 10 years fixed, 0 years indeterminate. I will impose that sentence and run it concurrent with count 1, and I will grant you time served. I will also, in that count, impose a fine of $10,000. I will impose court costs as set forth by statute. I'm also going to impose a fine of $5,000 under 19-5307, which shall also act as a civil judgment against yourself and will be entered on behalf of EB, KL, GN, KN, and JC, with $1,000 being apportioned to each of those victims, as the statute limits the fine and that charge to $5,000. Elsewise, I would probably enter more. Court will also issue, again, a separate order imposing that fine on behalf of those victims. The fine is ordered solely as a punitive measure against you. It is not based on any requirement of showing of need by those victims and is authorized under subsection 2 of that section. Mr. Stark, I've entered this sentence against you within the bounds of that plea agreement for the reasons I've stated. Someday you'll see the light of day again after you're released from the Department of Corrections. Do not consider ever taking this action again. There need not be another victim that have gone through what these victims have gone through because of your actions. I sincerely hope that you engage in the counseling, the self-reflection that you need so that this will never happen again. I sincerely hope that you internalize what you did. You come to grips with all of it. Because I don't think you'll be able to change unless you're able to acknowledge the extent of your actions and what you've done. Because my part's done here. It's on you to make sure that you don't harm another person. I can say that I appreciate the bravery of those young men coming forward. It could not have been easy. One of my concerns, honestly, it took 10 years before these allegations came out. Even in the psychosexual evaluation, the PSI, it said that your risk was mitigated by the fact that nothing has happened since. I sure hope that's the case, because it took 10 years for this to come out. But I don't take that into consideration here, because I don't have that before me. But I certainly do find that you're a risk, that I must protect society, and that you deserve to be punished. So I am entering that sentence. I will enter a judgment reflecting that sentence. I will remand you to the custody of the Department of Corrections so that you may serve that term. You have 42 days in which you may file an appeal. If you cannot afford the cost of an appeal or the cost of an attorney to assist you in that appeal, those costs can be provided for you. Gentlemen, is there anything else?
Oh, yeah, nothing.
Mr. Taylor?
No, Your Honor, thank you.
Thank you. All right. Then, as I stated, you are remanded. The court will be off the record until 10:30 for our next hearing. Thank you. All rise for the court.
One for Rainbow, one for Amanda.
Who you playing with, sweetie?
Amanda.
Oh, who are you?
I'm Amanda. I'm 6, and I love unicorns.
Sexual predators are seeking kids online.
We don't know Amanda.
Learn how to report abuse at end-violence.org/protect.
Broken clock on the back wall, counting down till the last bell rings. You lock the door with the plastic smile, say this is just our little secret thing. Ink stains on my test paper, your hand leaning where it shouldn't be. You twist the rules like a gold ring, say it's love, say it's meant to be. Leave the kids alone. Leave the kids